Good afternoon, everyone. My name is Sabina Mohideen. I'm the Executive Director of the American Muslim Advisory Council, and we work to empower the Muslim community across Tennessee. AMAC is a proud partner with the Eviction Right to Counsel program in Nashville. We work with Legal Aid Society, Connection Americas, Hispanic Bar Association, and other partners to provide free legal services to those who are facing evictions or having problems with their landlord. April is Fair Housing Month. So today we're here to discuss the protections tenants have under the Fair Housing Act and your rights as a tenant. So for the discussion, I would like to welcome Elizabeth Leiserson, who leads the Legal Aid Society of Middle Tennessee and the Cumberland's Housing Practice Group and serves as a project director for the Eviction Right to Counsel program based in Davidson County. After receiving her JD from Yale, Elizabeth spent 3 years with Southern Migrant Legal Services as a staff attorney and Skadden Fellow before joining the Legal Aid Society of Middle Tennessee and the Cumberland's team in October of 2022. So good afternoon, Liz. Thank you so much for joining us today.
Thank you for having me, Sabina. I'm really glad to be here.
Yes, it's been a great partnership with AMAC and Legal Aid Society. But today, with April being the Fair Housing Month, can you give us an overview of the Fair Housing Act?
I'm happy to do it. And Sabina, thanks again for having me. We're so glad to be here. I'm so glad to be here today to have this wonderful partnership with AMAC and the other groups who help make the Eviction Right to Counsel program in Nashville such an exciting program to be a part of. So what is the Fair Housing Act? The Fair Housing Act is a federal anti-discrimination law here in the US. So federal law, which means it covers all 50 states and the territories, applies everywhere. It applies to both private and public housing, so sort of doesn't matter who your landlord is. This is the law that says landlords cannot discriminate against tenants. It was passed all the way back in 1968 and is still in effect and very important today. And I will say we're focusing today on tenants, but all the stuff I'm going to say about the Fair Housing Act, it does also apply to other kinds of housing. So it applies like if you're buying a house or trying to get a mortgage, Fair Housing Act also applies there too. But our focus for today is on tenants.
Well, that's great to know. Who is protected by the Fair Housing Act?
So the Fair Housing Act, it protects based on groups. So this is sort of classic lawyer stuff. It picks groups of people and you can't discriminate on the basis of people belonging in those groups of people. And this is a thing that comes up a lot because sometimes people are like, oh, they're discriminating against me because they like somebody else better than me. Picking your friends is not discrimination. Discrimination is not a friendship is not a protected class under the Fair Housing Act. So the protected classes, they are, I always forget one of these. So if the race, color, national origin, religion, gender, and gender includes sexual orientation and gender identity, familial status, which is a weird one specific to housing, so you don't hear about it in other contexts as much. It's mostly talking about whether you're married and whether you have kids, and then disability.
So, as an immigrant or as a Muslim, are you protected under the Fair Housing Act?
Absolutely. Any of those categories can apply to immigrants or Muslims. There are people in the Muslim community who are disabled, who are getting discriminated against based on gender or anything else. The ones that are going to be most common for the Muslim community or for immigrants are discrimination on the basis of national origin. So, I don't want to rent to anyone who wasn't born here, that kind of a thing. Race, just flat racism, is against the Fair Housing Act. And then, of course, religion.
And so, what does the Fair Housing Act do for tenants? What can we ask for? How do we complain? What happens if we win? Like, how does this process work?
Sure. So the Fair Housing Act, it is a discrimination protection, which all by itself is a law that's worth the paper it's written on, right? So it's all about what tenants with assistance from groups like AMAC or Legal Aid or other attorneys can do to actually make those protections real and effective for them. Fair Housing Act lets tenants do a couple of different things. The two main ones that I'm going to talk about today, Number one, you can file a lawsuit against your landlord for violating the Fair Housing Act. And that includes if your landlord sues you. So most commonly that looks like an eviction lawsuit. If your landlord sues you, you can sue them back. Basically, lawyers call it a counterclaim, but you can sue them back for discrimination. So that's option one. Fair Housing Act lets you sue your landlord. Fair Housing Act also lets you file a complaint. There's a federal agency and a state agency that both oversee the Fair Housing Act. And so as a tenant, you have the right to file a complaint against your landlord or a former landlord. There's a time limit, so be careful if you're looking back. Don't go back to like a mean landlord you had in the 80s. That's too old. So you can file a complaint. That's free. It can be online. It's available in a lot of languages, and it can be less scary than going to court, which is of course a whole big process. Either of those things, lawsuits or complaints, what can you get? You can get money. When a landlord discriminates against someone, they may be entitled to money as like compensation. And you can also get orders to stop discrimination or to adopt non-discriminatory policies to do better going forward.
Well, that's good to know because sometimes you face the discrimination, you don't know what to do next. How do you get that help? So let's talk about some of the common problems that especially immigrant or Muslim communities face when you're talking about tenant-landlord relationships. And the first one is about language access. First question, can landlords refuse to rent to people who don't speak English or have limited English proficiency?
No, that's discrimination on the basis of national origin. So when I went through that whole list and said you can discriminate on the basis of whether or not we're friends, you cannot discriminate on the basis of national origin. And there's some really clear law and language from the federal government that says because being not an English speaker or speaking limited English is almost always because you or someone in your family wasn't born here, it's gonna basically be national origin discrimination. So your landlord is not allowed to say, you have to speak English, only English speakers. If you can't speak English, you can't live here. Not allowed.
So, but we know that tenants sometimes they face problems when they don't, when English is not their primary language. They sometimes have trouble getting services that they're supposed to get from the landlord. Is that discrimination?
It depends. And I know that's the most annoying lawyerly answer that you get all the time. Like, depends on the circumstances. But unfortunately, that is the answer here. For the most part, what a landlord has to do, if you only speak some English, you don't speak English very well, you're not super comfortable in English, they have to take steps that are relatively easy and relatively cheap that let you understand what's going on. But there's a lot of wiggle room there, right? They have to take sort of reasonable steps. They don't have to go hire an interpreter for $100 an hour because that's very expensive and a big hassle for them. But they do have to take reasonable steps. So sometimes it's unfortunately going to be a little bit on the tenant to say, hey, I need an interpreter at this meeting. I'm going to go sign a lease. Can I bring my sister or my cousin or my friend who speaks English better than me so they can help translate? That your landlord should say yes to. So if you are in that position where you're not super comfortable speaking English and you're trying to think through what you can do, start thinking about what you want your landlord to do for you that doesn't cost your landlord a ton of money. So maybe let you bring someone else with you. Let you make your requests in writing, because maybe if you're a little more comfortable with written English than spoken, maybe that's something you can do. Maybe it's, can I have a copy of this and take it home and have 24 or 48 hours to look over it, maybe with somebody else I know or I trust who can help translate for me. So your landlord's gonna have to take those reasonable steps to help you access the basics, but they're not going to, for example, have to make sure that your tenant portal is available in English and Spanish and Arabic and Somali and Kurdish. They don't have to do every single thing. They have to take reasonable steps to sort of meet you halfway.
No. And we know when you're sitting down signing a lease, it's very complicated language. None of us likes reading through every detail in English, let alone having to read it in a language that is not your primary language. And so what I'm hearing is they don't have to provide the translation services or the interpretation, but they should give you a reasonable accommodation for you to bring a friend, a relative, and give you that time frame to read it, and not like push you sign it right now when you're like uneasy about it because you don't quite understand all the terms.
Exactly. So landlord has to meet you. I like the idea of meeting you. They have to meet you halfway. So if you have a proposal of like, here's what I can do to make it so it's not super expensive for you, landlord, and it's not going to make your life super complicated, meet me halfway. Let me bring a friend with me. Let me take a copy so I can review it. That your landlord should allow. And I wouldn't be a lawyer if I didn't say, read your lease, read your lease, read your lease. Read your lease. It's boring, it's long, but the devil is in the details. Read your lease. One thing I will also mention briefly, Sabina, because we talked about interpreters. There are some housing providers who get federal money who may actually have to provide interpreters, but it depends on whether you get a lot of federal money. So if you're in certain kinds of federal public housing, subsidized housing, if you have the kind of housing where your rent is set at like 30% of your income, if that's the kind of situation that you're in, your landlord may actually have to do more. They may have to provide that interpreter for you, but it depends on whether you're in that particular kind of housing. And people can get a little confused by that. So it's a good place to call an attorney. You can call legal aid, talk to AMAC, and we can help you figure out if that's your situation where your landlord does actually have to do more, because that's a condition of getting federal money.
Well, that's good to know. That's good to know. So, yeah, thank you. Thank you for clarifying that. Another common problem that we see is around repairs, asking for repairs, people saying, well, my landlord is not doing it, and whether this falls under discrimination or not.
I'm going to give the awful lawyer answer again. It depends. You can imagine circumstances where it is discrimination. Like if everyone is getting repairs except you, and the only thing that's different is that you're Muslim or that you're an immigrant, and your landlord starts saying things about pick your slur, go back where you came from, that kind of thing, then yes, that's discrimination. That's the kind of thing where you could file a lawsuit or you could file a complaint. A lot of times it's in that sort of messy middle area where it sort of seems like it's harder for you than for other people. Like the landlord is maybe slower for you, or a neighbor got something fixed, but you haven't done, because who can, an exhaustive survey of all 100 of your neighbors to confirm exactly who got what repairs when. So it might be. If you're not sure, you can always call a lawyer and we can talk you through about whether you have a case for discrimination in your particular circumstances. But in general, if it's repairs, I'm always going to give everyone the same advice.
So, it's always, I would say you're always in kind of that doubtful situation. You're not sure they're discriminating, but you really feel it in your gut, but then you don't have the proof. Um, what kind of what would you advise people in terms of keeping a record of what you think might be discrimination?
Sabina, you're making my lawyer heart happy. We love records. Do things in writing. That's going to be my number one recommendation, sort of regardless. If you think because they're not responding to you, let's say you want repairs and you're not getting them. Maybe it's discrimination. You've got that sort of feeling in the back of your brain, like it might be that, but also maybe they're just incompetent, or maybe they're mean, or maybe they have 4 new staff people who haven't been trained and their IT system is broken. We don't know, and it's a little hard to know. So my advice to you on the front end is always going to be the same, which is get it in writing, keep records, be persistent, but be polite. So those are always going to be my 3. So pretty much any issue, you're having trouble getting your landlord to make repairs. They aren't responding to you with your questions about the mailbox. You're trying to figure out if you're going to be able to renew your lease and they're not letting you know. I'm pretty much always going to tell you to do those same things. Do it in writing. So do it via email. Email's
Mhm.
the best because there's a record
Yeah.
automatically and you're not going to accidentally lose it. If you can't email or your landlord doesn't use email, you can do a text message. Take a screenshot of the text message so you don't accidentally lose it. If there's an online portal that you have to use the online portal, but again, take a screenshot because the online portal belongs to your landlord. So sometimes they will like clear out old requests or something once they think it's handled, even if you don't think it's handled. So do this in writing, keep your records, document, document, document. So if you have a conversation with someone on the phone, then you send them an email afterward. Oh, thanks so much for talking. I really appreciated when you said da 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 da. If there's a repairs problem, take a picture. Take pictures. Pictures are worth 1,000 words. And then number 3, be polite and be persistent. So it's going to be on you sometimes. Even though it feels like the landlord should just do this automatically, it's going to be on you sometimes to take that extra step and follow up. Hey, it's been 48 hours. Really appreciate your help. Remember, you're still being polite. You're usually not going to get anywhere by accusing them of things. Be polite, be persistent. Hey, it's been a couple of days. I still really need this. Any updates you can provide? Thank you so much. Wait another few more days. Hi, just trying in one more time. Really appreciate everything you're doing. I know you're busy. This is very important. Keep going. It's going to be on you to keep going. And if you have that in writing, whether it's discrimination, whether or not, then you have this long history that you can show someone to prove that it's not just in your brain.
And so suppose they're not making the repairs, then what do I do? What would somebody do?
My same basic steps. Number 1, make your request in writing. There's a form that Legal Aid has uses and that AMAC has helped us translate into a whole bunch of different languages, including Arabic and Kurdish and Pashto and Somali, I think a couple of others. You can use that form if you want. It's really detailed and has some sort of legalese in it. So if you want, you can go through, use that form. You don't have to. Do your request in writing, take your pictures, be polite, be persistent. If it still doesn't work after you tried all of those things, that's when I normally recommend that you talk to a lawyer. You can call Legal Aid, you can talk to AMAC. You may have some options. So one is you may be able to break your lease. Your landlord isn't holding up their end of the bargain. You may be able to move out early. You might be able to sue them if they're still not making repairs. Number 1 thing I want you to know though is please, 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 please don't stop paying your rent. This is my number 1 thing about repairs. Don't stop paying your rent.
I think that's we've seen this before where people have, well, they didn't make the repairs. Why do I still owe them money? But it's a contract that you signed, your lease, so you still obligated to pay the rent.
Exactly. And and I understand, it makes some sense. They didn't hold up their end of the bargain, so why do I still have to do it? The reason on the absolute most practical level is if you don't pay your rent, you can end up being evicted with the problem still not fixed. So if you don't pay rent, your landlord can start an eviction lawsuit. And the fact that they didn't make repairs, the way the law works in Tennessee doesn't mean you get to stay in the apartment if you're behind on rent. There are some other states where the law is different. I started off talking about fair housing law, anti-discrimination. That's a federal law, applies all over the country. Now, when we're talking about repairs and paying rent, that's going to be state by state. And in Tennessee, you do not have a right to withhold rent. There is an exception that is like this narrow, and it is so complicated that what I just tell everyone is unless a lawyer has told you you don't have to pay your rent, keep paying your rent. Keep paying your rent. Even if you think your landlord owes you money because of the repairs or the problems, pay your rent and then ask them for a refund or a credit. But you make sure you stay up to date on rent so that they don't have any excuse to bring you into court. Because that's what's going to end up in the worst situation.
So that's very important information to know, because you feel like you're wronged, and you should be able to take some kind of action. But then if you're in doubt, you don't know. That's what um, the Legal Aid Society hotline or AMAX hotline to call and find out and have those questions answered. So thank you for that. So
I will
let's
say,
okay.
when you're trying, you want to know what you can do? The one thing I want you to remember, you might be able to break your lease. Don't stop paying rent, but you may be able to just move. Still a good idea to talk to legal aid or AMAC, but think about it that way. If your landlord isn't making repairs, start looking around, because maybe there's another place you could move that would be better. And if you're still having problems when you find a new place, maybe you can move. And if the reason you have to move is because the landlord isn't making repairs and it's been an ongoing problem, you may be able to move without paying any of those like fees or penalties that are probably in your lease. So again, good to talk to a lawyer before you do it. But rather than thinking, oh, my landlord's not they're holding up their end of the bargain, I'm going to stop paying rent. I want you to think, I'm going to start looking for a new place and I'm going to talk to a lawyer.
Thank you, Liz. I'm always learning something new. So that's great advice. So let's talk about evictions. So when you get to, yeah, problems you're having with your landlord, um, can I lose my housing if I complain about discrimination, or, I report the landlord for discriminating?
Uh, no. So that would be retaliation. So your landlord is not allowed to retaliate against you because you filed a complaint related to discrimination, or because you requested repairs or made some other request that is allowed under the law. So retaliation, big lawyer word, but essentially they're not allowed to evict you because you tried to file a complaint. They're not allowed to try and raise your rent because you filed a complaint. They're not allowed to treat you worse because you filed a complaint. The problem, I'm guessing you can maybe already see where I'm going, is it's that because, it's proving that it's because.
Hmm. So, so discrimination problems, do they ever turn into eviction cases?
Yes, unfortunately they do. And these are the ones that really break my heart, and why I'm so glad that we're here today giving some of this information on the front end. Because what starts off as discrimination, mistreatment, a landlord not behaving right, can really easily end up with an eviction lawsuit, which ends up hurting the tenant more than it hurts the landlord. So what might that look like, where what starts out as discrimination ends up as an eviction lawsuit? So one common way is the one we already talked about. Landlord starts not doing right. They're not making repairs. They're hassling you. They're discriminating. They're behaving in some way that's inappropriate, discriminatory. Tenant says, fine, you didn't hold up your end of the deal. I'm going to stop paying rent. Ding, ding, ding. Once you're behind on rent, your landlord's going to file an eviction lawsuit. Not always. A lot of the time, your landlord will then file an eviction case. So that's one really common pathway. Another one that we see sometimes can be about the tenant's response. If a landlord says something really awful and the tenant gets upset, and then all of a sudden the landlord feels like it was, how dare you speak to me that way? And then the tenant gets the eviction notice, even though the landlord started it. And that's all because the person who files an eviction lawsuit is the landlord. So you have to, when you're the tenant, you have to take a deep breath and try to think, how's this going to look to my landlord? Is my landlord going to think that I'm the problem, that I'm the one who's being rude or inappropriate or dangerous, even though the landlord is the one that started it? That gets back to one of my earlier recommendations where I suggested you do things in writing and that you be polite as well as persistent. It's a lot harder for things to escalate that way if you're just sending emails back and forth. Excuse me, I wanted to check in. Thank you so much. And that's annoying to have to do that, but it really is a good way to protect yourself.
Well, the scenario you just described is something, an exact case that came to us, discrimination and how a tenant was being treated. Well, before, when he was signing the lease. So this is real. And people will push your buttons and say things to you, but being polite and being persistent, I think it's just kind of knowing you are in the right, but for your own sake, um, being polite and persistent is great advice.
Yeah, and be polite in writing because it's easier,
Yeah.
right? When they push your buttons, you can do the thing, draft the email that says everything you want to say, and then send it to your mom or your sister, friend, and say, "Hey, is this okay for me to send this to my landlord? Sleep on it, send it in the morning when you can take a deep breath." That's why written communications are so good for so many reasons. It's helping you document what's going on. If they're saying awful things, you have it in writing. So there it is right there on paper. And it gives you a chance to take a deep breath and cool down so that they can't say that you're the problem.
Mm, well, that's great advice. So what happens if somebody does get an eviction notice?
All right. Bunch of things happen all at once. So, first thing I want to talk about is what it means, eviction notice, because there's a lot of different things that people get that could be called an eviction notice. So one thing is you may get a letter from your landlord that just says, "Hi, you have X amount of days to be out." And it's just a letter. This was a problem. I'm giving you maybe in some cases as little as 3 days, maybe 14 days or a month, and then I would like you to leave. That is a notice that an eviction is going to be filed, but it's not a lawsuit yet. And at that point, that's something that I want any tenant to take really seriously when you get that letter from your landlord that says you have 14 days or 30 days or 3 days. Take it really seriously. It's a good time to call an attorney, call AMAC, call legal aid, call a private attorney if there's someone you know. Because that's the moment when your clock is going to start ticking, and that may be your last chance to resolve this before you go to court. Once you go to court, it's a public record. Future landlords can see it. It might get held against you. It may end up going on your credit. So take those original notices, those letters you get from your landlord, really seriously. Consult with an attorney. You can still talk with your landlord about it if it's a misunderstanding, if it's wrong. That's totally fine. You're still allowed to communicate with your landlord. Again, I would suggest do it in writing, be persistent, be polite. "Excuse me, this says that I'm behind on my rent. Here's attached is the receipt that shows that I just paid. I don't understand. Can you please let me know as soon as possible what amount I still owe, and I will try to pay it as quickly as I can." Take care of it quickly. It's really scary, and sometimes our tendency is like, "Oh, I'm just gonna ignore this. Everything else is going on. I have so much else going on. I have my work, I have my kids, I have my family. I'm too busy for this." But take that one really seriously immediately. So that's the first step. Second thing, and I will say there won't always be a first letter, but most of the time there is, but not always.
Mhm.
Second thing that happens is a lawsuit notice. That one it's called in Tennessee a detainer warrant, which is the worst name. It sounds like arrestee arrest paper. It sounds like you're being arrested, like you committed a crime. I hate it. Like it's a warrant for your
Mhm.
arrest. It's not. It's called a detainer warrant. It should be called a notice of an eviction lawsuit. If you get that one, you've got a court date and you need to start making plans right now. Like yesterday. You need to talk to an attorney if you think you need one. Call AMAC, call support services, start making plans for what happens, worst case scenario, if you leave. Can talk folks more through sort of the timeline, but I'll pause there because there are these sort of two different things that you might get from your landlord. One is just a letter. It's a notice that says you have some amount of time. Take that one real seriously. You may be able to work it out. Second one is the court notice. It's called detainer warrant. Again, hate the name. That one means you have a court date for an eviction lawsuit, and you need to start making plans for what you're going to do at court and also what you're going to do if you have to leave. Last thing I'm going to say, and then I'm going to let you ask another question because I know I'm talking a lot. you may not get this first notice before you get the court notice. There's a rule in Tennessee that says if you're behind on rent more than 5 days, as long as your lease has some magic words in it, and most of the leases have magic words in them, your landlord can go straight to court without giving you that pre-court notice. So don't think, oh, I know I'm behind on rent, but as long as they haven't sent me a letter, I know I've got a little more time. Because as long as we're on day 6, your landlord could file that eviction lawsuit notice on day 6.
So now you have an eviction notice. Suppose I just decide to ignore that and
Please
not go to court.
You will make me very sad. But if you ignore it, so you got that, maybe you got that first notice, that letter, it said you owe money, but you couldn't afford it, whatever. Maybe you didn't even get that notice and you just immediately got that court notice, the detainer warrant, the eviction lawsuit notice. If you don't go to court, you lose automatically. It's like there was a baseball game and you didn't show up, so you forfeited. Automatically lose. As long if your landlord shows up or your landlord's lawyer shows up, you don't, you lose. And you're going to lose to whatever amount they said you owed. So if you get that paper and it says you owe $6,000, even though that's wrong, you only owe $2,000. If you don't show up, they're going to get a court order, a judgment from a court that says you owe $6,000, and then they can start trying to collect it. They can start trying to garnish your wages, garnish your paychecks, find bank accounts, report it to credit agencies. So really, really, really important. If you take away one thing from this, it's don't stop paying your rent. If you take away 2 things, it's don't stop paying your rent and go to court if you get a court notice. Because if nothing else, you can at least get a chance to make sure that the amount you owe and the amount they try to collect is right.
And so we've talked about this before with this eviction right to program and why it's so important, that oftentimes people will be like, well, hey, I'm in the right. The tenant, the landlord, he was mistreating me. I just need to go to court by myself and explain it to the judge. What is your recommendation if somebody feels like, hey, I can just speak for myself, I don't need a lawyer?
You have the right to talk to a judge by yourself. That's totally fine. I will recommend, I mean, take it with a grain of salt because I am a lawyer, so I think lawyers are very valuable, but it is really useful, even if you aren't going to be represented by a lawyer, to talk to a lawyer so that you understand the way the system works. And one of the most important things to know is that the way Tennessee law is written, this is for Tennessee, not necessarily true in other states. If you're behind on rent, you have like 1/2 of one potential defense that might keep you in the apartment. If you're behind on rent in the state of Tennessee and your landlord files a court case, you are probably almost certainly going to have to move unless you can work out a deal with your landlord. And so this is a thing I talk to clients about probably 5 times a week. Your landlord can do a whole lot of illegal things, a whole lot of things that are wrong, that are even truly against the law. And if you're behind on rent, you can still get evicted. And that's because in Tennessee law, when there are evictions, there's always 2 issues in an eviction case. One is what lawyers call possession, but it just means, do you get to stay in the apartment? The other is what lawyers call damages, but it means money. So do you get to stay and money? If you're behind on rent, you almost always are going to lose on the question of do you get to stay? So if you're thinking, I'm going to go to court and the judge is going to understand that my landlord has been mistreating me, good chance when you go to court, first thing the judge is going to say is, are you behind on rent? And if you say yes, the judge may basically stop there. And all this other stuff that's happened, none of that is a reason that you get to stay in the apartment. Because that's issue number 1. Do you get to stay? And the way the law is written in Tennessee, if you're behind on rent, you usually don't get to stay unless you can work out a deal with your landlord. All that other stuff your landlord has done, that stuff that is illegal, it does matter if you go to court, but it's all going to go to the question of money. So if your landlord says you owe $2,000, but you can show that they haven't fixed that there's been a leak in the bathroom for 3 months and you've had to replace $1,000 worth of stuff, you're probably still going to have to move, but in the end, maybe you only owe $1,000 instead of $2,000, if that makes sense. So backing all the way up to your question, if you think, hey, judge is going to understand my side of the situation, you absolutely have the right. You can go to court and you can talk to the judge all by yourself. But I'm going to suggest it's a really good idea to at least talk to a lawyer first to get a second opinion about what's likely to happen. And so you can prepare. Because the law in Tennessee is really strict, especially if you're behind on rent. And even if you're not behind on rent, let's say you're getting kicked out because of something that happened, like some altercation, that situation we were talking about before, someone's being really nasty, racist, mean, inappropriate to you, and you respond, and hey, maybe you get a little heated because what they said was inappropriate, racist, awful, and you think, I'm just going to be able to tell my side to the judge. It may work, but a lawyer can be really helpful in knowing things like, Your Honor, this was a violation of the Fair Housing Act. And this is why this is a fair housing claim that is, and a lawyer can help you frame all of that in a way that can be really useful. So that's my pitch for why it's worth talking to a lawyer, if only to understand a little bit about what could happen.
And we've seen with our experiences with actual cases where, and the wonderful lawyers at Legal Aid and the Hispanic Bar Association have been able to talk to the landlord's lawyer and work something out before the case even went to court. And that's always a win for the tenant. Like, you didn't have to go that far. I had a question. Just because you got an eviction notice and you weren't actually evicted, does it go on your record if you're looking for another apartment or house to rent?
Yes, with an asterisk. This asterisk is because people ask me a lot about, like, is it on my record? And we have this idea that you have like a record, and it seems like it's a piece of paper that lives in a filing cabinet somewhere, and it is one thing, and you can get it fixed to where it has something or it doesn't. And unfortunately, it's not how it works. Your record, what we call a record, is sort of a compilation of what exists about you on the internet. So any lawsuit that has been filed in court becomes a public record. So what does that mean? If your landlord files a lawsuit against you, Nashville Realty Co. versus Liz Lyserson, and we get it dismissed, we work it out, I have the money, they agree to let me stay, I get to stay in the unit. And I think, great, I wasn't evicted. There's no eviction on my record. And it makes sense, right? Because I think I got to stay. I wasn't evicted, so how could it look like an eviction? But what you have to know is what we're talking about when we say record is that public record that exists that says Nashville Realty v. Lyserson is a case that existed. And some future landlord can pull up case records and say, hey, look, Liz Lyserson was in this lawsuit before. Even though they worked it out, I'm going to say maybe she feels like she's kind of a problem or an issue, and maybe not rent to her. So as soon as your case is in court, there is a public record that someone could find, that a future landlord could find and see. That said, if the court record says the case was dismissed, that's something you can probably explain to a future landlord. Hey, yes, they filed it against me, but here's the notice where they dismissed it. It was a misunderstanding. I took care of it right away. And usually people are able to move on from that.
Okay, well, that's good to know, because people are, worry a lot and are just kind of eager to get it over with and not challenge the eviction because they're afraid it'll be on their record. Um, so, and then one question we had is like, what if you're behind on your utilities? Is there a clause on your lease that they can evict you because of that?
With utilities, it gets really specific. So, um, different leases handle utilities in a lot of different ways. And then what happens if you miss a utility payment will depend on the way your lease handles it. So some leases say utilities are your own responsibility. And if you miss your utility payments, well, maybe your lights get shut off eventually because you didn't pay the bills, but your landlord won't do anything in particular. If your lease says like, some leases will say, yes, it's your responsibility, you pay directly, but if it gets to the point where your utilities get shut off, then your lease might be terminated. And that is a clause that a landlord could follow through on. So very important to stay up to date on your utilities if you can. If you're behind on utilities and just don't have the money, in addition, you can call legal aid, call AMAC, a great place to start if you just need a little bit of help on bills. I always recommend 211. It's a phone number. It works here in Nashville, works all across most of the country. It's run by the United Way, and they're sort of a clearinghouse. And so you can call for other nonprofits and groups that have like money or resources to help you with different things, including sometimes utility payments. So if you're a little behind on utilities and you just need some help, call 211. And same, if you're behind on rent, call 211. And they'll know. They won't help you right there usually, but they should be able to give you the phone numbers of the groups that may be able to help. And then if it gets to a point where, if you're thinking, so sometimes we get this call of like, is my landlord going to evict me because I'm behind on rent or because I didn't do this thing or because I didn't pay my utilities, whatever the case may be. My answer is going to be, I don't know. Because probably your lease says they can do that, but will they? I don't know. They might or they might not. So in that situation, usually I'm going to fall back on the same advice, which is communicate with your landlord and document what's going on and be clear. So that same things, keep your records, document, be polite, be persistent. Make sure they know, hey, I got this letter from you, or the person asked about what's happening with my utility payments. Please don't worry, I have it under control. I'm going to have it fixed. Your landlord's not going to like not notice. So you might as well communicate with them on the front end. If you do get that notice that says you have X many days, you have 14 days before we file this lawsuit, or worse, the court notice that says you're behind on your payments, well then, same as everybody else, you need to go to court, you need to have a plan, good idea to contact a lawyer.
So when you actually get the eviction notice, so for people who have limited English proficiency, is that eviction notice ever translated in the languages they need?
I wish. So with the asterisk of the public subsidized housing, so I'm not going to talk about those because they have way more specific rules. They may have to translate it for you. Depends on what county you're in, what kind of housing you're in, what population they serve. Other than that, normal rule is they won't have to translate it for you, but you should get it in writing and you will always have some time. So if you get that eviction lawsuit notice, minimum you should have 6 days. 6 days from when you get the notice until your court date. So you have some time then when you can do the same things we talked about before. Find a person you trust, find some help, someone who can help translate this for you. Also, the court system does have to provide interpreters. So they normally don't do written translations, but you can call the court office to request an interpreter at your court date. And then at the court date, there will be either a phone interpreter or an in-person interpreter. So here in Davidson County, they have in-person interpreters available at the courthouse for Spanish and for Arabic. Other languages, they use a phone-based interpreter system. So worst case, once you get to court, you should be able to access an interpreter. I know that's a long time, but that can get you started.
I know sometimes people are like, well, I know English well enough. So, but these are legal terms that are being discussed. What would your recommendation be?
Yeah, these terms are going to fool people even if you speak English as your first language because you don't speak lawyer. Unless you speak lawyer, it's a good idea to talk to a lawyer or somebody who does understand these complicated terms. Some of the things I talked about, like that, remember that eviction lawsuit notice is called a detainer warrant. I don't care how good your English is. Even if you went to law school and you didn't do landlord-tenant law, that sounds like you're being arrested. So all of these papers, if you think my English is fine, I can get by, I really strongly recommend speak to someone who's fluent in English and preferably speak to a lawyer. For your lease, if you're back at the very beginning, you don't have to review that one with a lawyer. But do get somebody who speaks English really fluently to help you with some of those tricky parts. And then when you're at the point of getting court paperwork, good idea to talk to a lawyer to make sure you understand all those details because it's hard even for folks who speak English perfectly.
Yes, yeah, thank you for that. I mean, in the work that we've been doing with AMAC and Legal Aid Society and Hispanic Bar Association, we've had clients with limited English proficiency, and we've been very intentional in making sure that there's an interpreter online or in person to explain exactly what's going to happen, what is the process, and for the lawyers to get the full story of what prompted this eviction or these problems. So I definitely recommend, unless you have really good English, do get an interpreter. It will really help you through the process. And it's also a comfort level when you're really under stress because of an eviction to be able to explain things in your own language really helps. Um,
And when you're going to court, if you do have a court date, let's say you're going to court, but you didn't find out about it until a day or two before because things happen and life got in the way. You didn't have time to call AMAC or legal aid or the Hispanic bar, so you're there on your own. Bring somebody with you to court. Preferably if you have somebody who speaks even a little more English than you, or even if your English is perfect, who can just be there for moral support, bring someone with you to court because court is scary and hard and overwhelming. And having another person there to help you, to make some suggestions, to make you feel a little more comfortable, and especially if your English is like only so-so, someone who can just, even if they speak enough English, a little more English than you, and can help you explain to the judge that you need an interpreter, right? Because you can get stuck at step one. How do you say, I need an interpreter for Kurdish? And they think you need an Arabic interpreter and you haven't even gotten all the way there to what you need. So bring someone with you to court too.
so what other resources are available for people facing eviction?
So a couple that we've already talked about here. So obviously, a big fan of Legal Aid Society. You can call us 833-837-HOME is our intake line. Of course, also AMAC is a wonderful partner. I'm sure you guys have your information in the chat for how to contact you. There are other members of the Right to Counsel Coalition if you're here in Davidson County. So the Nashville Hispanic Bar Association, we've mentioned them several times. We can give you their information as well. If you have an issue related to discrimination, something we talked about a lot, because this is about Fair Housing Month after all, the Tennessee Fair Housing Council is a nonprofit that specializes in doing disability discrimination lawsuits and complaints and demand letters. And they're real specialists in the area of discrimination. They're a great office to call. We'll put their information in the chat as well. And I'm going to mention again what we said earlier, 211. That's my favorite one-stop shop for resources. Most folks who are facing eviction, at least one of the things that's going on is that you need some help, right? You need some help accessing benefits. You need some help with finding work, with finding a little bit of rent relief, with help on the utilities, with issues around childcare. You've got some other stuff going on. 211, like I said before, they're like a clearinghouse for all the different nonprofits. They don't help you themselves, but they know this is where you go if you need to talk to, if you need help with transportation, you need to get the disability access ride system. That's how you can access that system. That's how you can access, these are the childcare resources in your area. These are some employment resources in your area. This is help applying for benefits that you might qualify for rent relief programs, for utility assistance programs. 211 is a great place to start if you're just trying to figure out who might be able to help.
Thank you. Thank you. That really helps because we always see that people who are usually facing eviction, they have other issues going on in their lives, and there are a lot of resources that they are needing at that moment in their life. So again, calling Legal Aid Society or calling AMAC or Hispanic Bar Association, it's just talk to the lawyer, talk to someone who knows where the resources are, who can get you to a lawyer. Don't feel like you have to go through this alone. And even if you feel like, well, yeah, I didn't pay my rent, I'm at fault, but maybe there's some way we can work things out. I think one last question I've heard before, like even before a court date, suppose your landlord tries to kick you out of your apartment, and can they do that?
No, they can't. It is not legal. This is what the law calls like self-help evictions. Self-help evictions are not allowed. Your landlord cannot just say, you gotta go. They can give you a notice that says you have 3 days to move out, or 14 days to move out, or a month to move out. That's allowed. But what that means is after 3 days are up, I'm filing in court. After 14 days are up, I'm filing in court. It does not mean on the very next day, I'm going to be showing up with movers and breaking the lock and coming in. That's not allowed. Your landlord has to go through the court system. And that can be really important, coming back around to what we were talking about with retaliation and discrimination. That can be sort of empowering, because someone might hear they're trying to report discrimination, retaliation, landlord behaving incorrectly, and the landlord responds by saying, if you don't shut up about this, I'm going to call the police, I'm going to call ICE, I'm going to get you in trouble, so I need you to shut up and move out. That kind of thing. They can't just call the police or call ICE or call someone to make you move out. They have to go through the court process. They cannot just threaten you, remove your stuff, take your things out, throw it on the yard while you're not there. That's not allowed. They have to go through the court process. So when you get those notices, take them really seriously. Start making plans. I tell folks every day, hope for the best, prepare for the worst, right? Hopefully the court's going to agree with you. You'll be able to work something out. That's excellent. But know where you're going to go if it doesn't work out. Start making plans. What's your plan? Plan A, plan B, plan C, because your housing is too important to gamble on. But they do have to go through that court process, which is important in part because that gives you a moment to tell your side of the story to the judge and potentially, talked about at the very beginning, to sue them back. If they've discriminated against you, if they violated the law, if they didn't make repairs, that moment when everyone has to come together in court, that's your chance to raise some of those issues. And again, a lawyer can help you raise them the right way. Because sometimes if you think I'm just going to be able to tell the judge my side and everything will work out fine, I hope so, and it may, but a lawyer can help you present it so that the court will really pay attention and give you a better chance of getting the right outcome.
Well, that's great information to know. I know we've heard that question before. So one last question, or I'll just mention it because on the Legal Aid website, we have a number of flyers that explain, like, what do you do if you're behind on rent? What do you do if you get an eviction notice? What do you do if your landlord is not paying, is not making the repairs necessary? There's flyers on Section 8 housing and how that works, housing resources, and they're available in many different languages. So we got Spanish, Arabic, Kurdish, Somali, Amharic, Dari, and Pashto, of course, and English. So, it's really, I mean, a lot of people kind of suffer in silence. They don't know what to do, and they just think, well, they have to do what they're told to do. But there are resources. Nashville is really making headway with this eviction right to counsel program. We have seen it, Liz, you've seen it. We've seen it with AMEC, all the families that have been able to stay in their home because they got the legal representation that they needed. And so, again, we thank you so much, Liz, and all our partners for the incredible work you're doing to educate our communities about their rights as tenants and what they can do, and trying to keep people in their housing, because housing is a human right. We should all, be able to be safe and have a roof over our heads. And whatever way we can help, we're here for that. So thank you, Liz, for educating us and being such a great resource for the community.
My pleasure. Thank you for having me. And we're so grateful to AMAC. I mean, we don't get all those translations into all of those wonderful languages by ourselves. We've had a really wonderful partner in you, and I'm really glad to be able to do this and try to reach another piece of the community. And I realized from the chat one number I didn't say and should have. If you go to court and you lose, your worst case scenario is always going to be 10 days to move out. So this is an important number that I repeat all day, every day, and someone just mentioned it in the chat. Everything goes wrong. You get that original notice, that detainer warrant, you have 6 days, you have a hearing, you go to court, you have 10 days to move out. 10 days is your worst case scenario. And that's scary and really hard, but it's not, you're going to have to move out that same day. So I just want to make sure everybody knows that. I know it's not quite the closing that we were on, but since it came up and I hadn't said it.
Thank you. Thank you so much, Liz. And thank you for everyone who joined the session today. And we look forward to doing some more in the future. Thank you.
Happy to do it anytime. Thank you, Sabina. Really appreciate y'all.